to file affidavit in opposition on behalf of respondent number 1, 2, 3, 4, 8, and 10. Listed on 1, 10, 20, 24. Okay.
Well, the third is also same. The respondents were supposed to file their affidavit.
Here also.
Yes, madam.
Why this same petitioner?
Well, the same petitioner could access documents in the public domain and RTI. This is also a matter where massive corruption in public departments were taking place. And we could document that fake documents were made and contracts were executed, money taken, defrauding the state exchequer. And in fact, since the respondent did not come on the last occasions, it was published in the newspaper also in terms of the court's order.
What about the other respondents?
Well,
We are appearing for respondents number 12, 15, 16, 18, and 20 lordship today.
Okay. What about the others? You are for 12, 15 to 20.
16, 18, and 20.
That is 12 to 15 to 20.
No, your lordship, not for
12, 15,
16, 18, and 20.
16, 18, and
20.
what about the others?
Yeah, Lordship. Lordship, I am for the respondent, private respondent number 14.
Who's for the state? Mr. Ratan,
Yes, ma'am.
you are for
1, 2, 4, 5,
1, 2, 4,
5, 6,
5, 6,
7,
and 7.
9.
7,
9.
7, 9.
Yes.
7, 9. You're for 3 and 8. You're standing counsel? Yes. SC, which department? RWD. Which are the respondents? Yes, and you.
I'm appearing for respondent number 10.
You?
Also, I'm for respondent number 13. And today I'm filing my counter affidavit.
What about the affidavits?
I am appearing for respondent number 12, 15, 16. And yes. So first time appearing, and so sometime is required for filing of
What
affidavit.
Have you received the
Yes.
copies, Mr. Ratan?
Yes.
Have you filed your affidavit?
No, not yet.
Acha.
And I am appearing for 11 and 17.
Are you filing your affidavit?
No, madam.
You're for respondent 10.
Number 10, madam.
You are not filing.
No, madam, because on the last occasion, madam, I was supposed to place the latest status report, madam, and I placed it, madam, before this honorable court. The basic allegation is that, madam, the case has not been registered, madam.
The cases?
Not been registered, madam. But then since there is an embargo under 17A of the.
You are actually a standing counsel or a special prosecutor?
Yes, special public prosecutor for the vigilance, for the vigilance department.
SIC.
Yes, ma'am.
The honorable wanted an up-to-date status report. Well, in the meantime, since the other respondents have come today, it will be fair if they are given some time to file their counter. Let it be fixed on the date, Your Lordship, on
Mr. Ratan, Mr. Ratan.
Yes, ma'am. N. Ratan.
N. Ratan, the Leonard Additional AG for the state respondent number 1, 2, 4, 5, 6, 7, and 9. Okay. Your good name?
A.K. Misra.
Mr. So-and-so, Leonard Counsel for the respondent number
12, 15,
15, 16, 18,
and 20.
Mr. So-and-so, Leonard Standing Counsel, RWD for the respondent number 3 and 8. Respondent number, Mr. So-and-so for the respondent number 13.
Mr. J. Karbak.
And Mr. So-and-so, for the respondent number 11 and 17, are all allowed 4 weeks' time to file their respective affidavit in opposition. Stop. Mr. So-and-so, the special PP, SIC, Vigilance,
My lord.
shall also place the status report on the next date fixed, listed on 1/10/2024. Okay?
Oblige you.
Obliged.
Thanks.
Item number 4.
Yan ko muna.
This is item number. Yes,
Yes, Lordship, this is PIL challenging the entire act of Afwafa, Lordship. Preventive detention law of Arunachal Pradesh. Lordship.
pardon?
This is PIL challenging the constitutional validity of the one preventive
You are
law.
challenging?
Yes, entire act, Lordship. That,
What are you challenging?
Lordship, that preventive special comes under the concurrent list. So on that ground, state legislative does not enjoy the absolute power. So it has to be sanctioned by president, and without sanction of the president and assent of the president.
We are not getting you properly.
Yes, now Lordship, this state preventive law, that it comes under the concurrent list, which means that state legislative does not enjoy completely. There is condition, and this act has to be assented by President of India, Lordship, because there is.
Mr. Leonard, Advocate General, can you kindly apprise the gist of this case? We are not getting him.
They have challenged the preventive detention law of the state. The act, my lord, the Unlawful Activities Prevention Act. Entire act has been put to challenge. That too by way of a PI. Okay. We are questioning the very maintainability of the PIL itself. How can you maintain a PIL? Your lordship will kindly come to the prayer. That will make the position very clear. It's a page 34. Your lordship will kindly see the prayer. The entire act has been put to challenge. That too by way of a PIL. All we are required to do on merits, well, all we are required to do is show the legislative will. That it is traceable to one of the entries in the list. And all kinds of sweeping statements have been made in the PI saying that the act is ultra vires.
And Lordship, period of the detention is very important. Once this is declared illegal, then entire act is illegal, Lordship. And moreover, advisory board, this has to be chairman has to be the sitting judge. That in Afwafa retired judge, Lordship. As per the 44 amendment, constitutional amendment, Lordship. And Lordship, regarding the FIL, there is already one case that entire act has been challenged through the FIL, Lordship. I have the case, Lordship.
We are questioning the maintainability on 2-3 different grounds. There are judgments I can place if your lordship so desire. Firstly, my lord,
You are actually challenging the whole act.
Yes, Lordship. Because Lordship, that this preventive detention, that there is a case of the repugnancy, case of the inconsistency with the Central Act. When there is a consistency between the Central Act, then under the 254 Lordship. Yes, 254 subsection 2, that assent of the president is needed, Lordship. This has to be complied, mandatory, Lordship. Either sanction previous sanction should be obtained from the president. Because Lordship, preventive detention, there is lots of the collide between the directive principle of state policy and fundamental right, part 3 and part 4. On that ground, that only union government, parliament is only permitted, Lordship. Because
Yes, Mr. Daniel, the petitioner says that it is only the Union of India which has the competency.
Your lordship will kindly take up the constitution. That answer is straight away I can answer.
Ah,
Your lordship will kindly have the constitution.
where is that constitution? Maybe. AC. Can you give some AC? It's so hot. It's very hot.
Your lordship will come to the concurrent list 3.
list 3, Lordship.
And your lordship will kindly see the third entry.
The Article 242.
No, your lordship will come to the schedule, madam, second schedule. The concurrent list 3.
No, that is in which article?
No,
Schedule.
Schedule
to
7.
the seventh schedule to the constitution. If we are holding the same book, it is at page 271.
Yes, Lordship. That it comes under
Concurrent list, your lordship will kindly see the third entry.
229 page. Union list.
No, the concurrent list 3.
Lordship, constitutional barrack, Lordship.
State list.
And
Concurrent list.
yes, your lordship will kindly come to entry 3. Preventive detention for reasons connected with the security of a state, the maintenance of public order, or the maintenance of supplies and services essential to the community, person subjected to such detention. So as soon as we show that the power is available under the concurrent list, the whole challenge goes. Since the challenge is to the whole act, we need to just demonstrate that it is traceable to entry in the either in the state list or in the concurrent list. There has to be, in any case, my lord, Supreme Court has clearly laid down guidelines so far as challenge to statutory provisions is concerned. Supreme Court is very clear that you cannot do it by way of a PIL like this. And secondly, it is their own statement. In paragraph 28 of the PIL, your lordship will find a specific statement that under this preventive detention law, 40 people were detained. Now, it will be in terms of the law laid down by the Supreme Court in SP Gupta's case. Those were the people who suffered a primary injury.
Correct.
Once those people did not come, who is he to come and challenge?
No,
They are the people, the law is very clear. If the people who suffer the primary injury do not come to the court,
The person who suffers secondary injury.
so who has suffered a secondary injury, how can he maintain a PIL? It is his own statement, rather. Your lordship will kindly come to paragraph 28.
You are coming on behalf of?
No, Lordship.
Exactly, who is he? That is
Yes,
the question.
Lordship, that I have ground. Lordship, that when that act is constitutional validity is questioned, then it is ab initio this void, Lordship, which means from the day that it came
You
into
are actually, basically, you are challenging the detention
Lordship.
of some of the detainees on the ground that the law is ultra virus.
Yes, Lordship. Yes, Lordship.
But actually, those persons who are detained and on whose behalf you have filed, they have no grievances.
No, Lordship,
They have no grievances.
Lordship, my ground is
Why are you so moto taking up their case when they want to stay behind the bars?
Lordship, ground is not just on that case, Lordship. My ground is when constitution validity is questionable, then from the day that it came into the existence, until today, that by the FIL also, by writ also, Lordship. Because, Lordship, this is that we are not going to look into the particular context. Rather, it should be through the constitutional jurisprudence. When act is attacked, state legislative act, it attack the spirit of the constitution, then Lordship, it is enough ground. Lordship.
How does it attack when the concurrent list gives
Yes,
power
Lordship.
to the state?
Lordship, may I come to the article 254, Lordship. This is one important, Lordship. 254, Lordship.
You want to brush aside the concurrent list?
The Lordship, this is main
Schedule
ground.
7.
Lordship, assent of the president is legislative procedure, Lordship. This has to be complied by the legislative, Lordship. Especially in Land Reform Act and Preventive Act, Lordship. And Lordship, since until and unless this preventive detention is protected by the Schedule 9, Lordship, and either it should be grant the assent of president under the 31C and under the Article 254, Lordship. This is mandatory, Lordship. And Lordship,
Okay, we will hear on the maintainability, we will pass order. We will hear on the maintainability and we will pass order.
Lordship,
Because the issue of maintainability has been raised. So we will first see whether actually the PIL is maintainable or not.
yes, Lordship, in course of my submission, that it will address the issue, Lordship, I will. That regarding the maintainability, Lordship.
Okay, we'll hear the maintainability first. Let us hear.
Then, Lordship, may I come to the Article 254, Lordship? Now, this has been established by this opposite party
200.
that preventive detention law comes under the concurrent list.
Article
Lordship.
200.
254, Lordship. May, Lordship. 254, Lordship. May, Lordship, read. Inconsistency between laws made by Parliament and laws made by state legislature of state. If any provision of the law made by legislature of the state is repugnant to any provision of law made by Parliament, which Parliament is competent to enact, or to any provision of any existing law with respect to one of the matter enumerated in concurrent list, then subject to the provision of the clause 2, the law made by Parliament, whether passed before or after the law made by the legislative of such state or case may be, the existing law shall prevail, and law made by the state legislature shall be extended to the repugnancy be void, Lordship. There is a one central act, Lordship. And Lordship, may I come to the
Well, what is your ground to submit that the law made by the state parliament is repugnant?
yeah,
to the
Lordship,
provisions of the central laws?
exactly, Lordship. There is unlawful activities
If
prevention.
under the 7th schedule, the concurrent list empowers the state also to make laws.
Yes, Lordship, that there is a one central act, Unlawful Activities Prevention Act 1967, where the jurisdiction of the court has been given. Now, the Apapa, there is no jurisdiction of the court, Lordship. This is direct collide. And now, regarding the advisory board, Lordship, advisory board, central act, sitting judge is advisory board, whereas under the Apapa, retired judge, Lordship. This is collide.
Under
the chairman is this retired judge, Lordship. Under the Apapa Act,
under
chair,
the what?
Lordship, under the Apapa Act,
This is
legislative act,
Apapa.
unlawful activities. This is Lordship. Arunachal Pradesh Unlawful Activities Prevention Act, Lordship. This is state act. When state act is as
Under
a
the state act, who is the chairman?
chairman is retired judge of the High Court, Lordship.
Retired judge of the.
And under the central act, the sitting judge of the High Court, Lordship. This is a collide. And now, Lordship, under the as per the 31C, Lordship, 31C, that if that the preventive detention, Lordship, it is under the framework of the directive principle of the state policy. While applying this policy, that state can make preventive law, but there is a provided condition that it can only validate it after the assent of the Lordship President, because he is constitutional head. Lordship, may I refer to 32, Lordship, 31C, Lordship, Article
31C of
31C.
what?
This is validation of this
31C of what?
article, Lordship, Constitution, Lordship, Article 31C, Constitution of India, Lordship. Lordship, that, my Lordship, 31C, saving the laws giving effect to the certain directive principle. Lordship, this principle that state make the law by virtue of the directive principle, not with understanding anything contained in Article 13, no law giving effect to the policy for the state towards securing all or any of the principle laid down in part 4 shall be deemed to be void on the ground it is inconsistent with or take away or abridge any right conferred under the Article 14 and 19, and no law containing a declaration that is for the giving effect to the policy shall be in the question in any court ground that it does not give any effect, provided that where such law is made by legislature of state, the provision of this article shall not apply thereto unless such law having been reserved for the consideration of President and has reserved his assent. Lordship, meaning thereby, until and unless this President of India give his assent,
Mr. AG, I think this will require a very detailed hearing.
I'll leave it to your lordship. I'm at your lordship's disposal. But so far as my humble understanding is concerned, if your lordship takes up on the maintainability issue, it's a matter should not take more than 15 minutes. But if your lordship goes into the merits, it will take time, 2-3 hours at least.
Because actually we want both the merit as well as the maintainability to be heard together.
So in that case, your lordship, I am at your lordship's disposal anytime.
We are giving you first week of September.
First week of September, there is a little bit of difficulty with that, subject to your lordship's convenience. Can it be on 24th of September? I have another matter fixed on 23rd, which is also likely to take the whole day. So your lordship will fix it on 24th. I'll stay back one more day.
Okay.
September. Okay.
Listed again for hearing on 24/9/2024. Because we are giving only 2 days in a week for DB.
I understand.
And the next week, Monday is Chutti, so only 1 day left for us.
I appreciate it. Deeply obliged.
obliged.
Ilya? What? With your lordship's leave,
May I, your lordship?
Yes, ma'am.
Your lordship, I beg to mention item number 20 to 23, your lordship, on behalf of AAG Irish number
22.
20 to 23.
Twenty to 23.
Yes, your lordship.
Yes. You're mentioning on behalf of
AAG,
AAG.
yes, Irish number. He instructed me to adjourn this matter today, your lordship, and this matter may be listed on
16th, my lord. I am for the petitioners in these cases.
16th of
16th of September.
Mr. MS Sonso, Leonard Council. Makes a mention on behalf of Mr. Ratan.
AAG, yes.
RH Nawab.
AAG Irish number.
RH Nabam, the Leonard AAG, and 6 adjournment of the case on
September.
16/9/2024.
But in all these cases, there are interim orders, my lord, that may be continued.
Prayer is allowed. The interim order passed in the writ petitions shall continue till the next returnable date.
with your lordship's leave, I'm mentioning item number 17. Lordship will just give me some accommodation. I'm seeking some adjournment because I had to leave for the principal seat before the division bench now. And the matter is item number 17. We have given our affidavit, but it was to be fixed for hearing. So can I request that this matter be taken up on the 1st of October along with
You're the counsel for the petitioner.
petitioner? Yes, Lordship. We had given our reply also. It was to be fixed for hearing actually.
Okay.
Since I have a
You're Mr. D.K. Das.
D.K. Das. Just
On the
some.
prayer of Mr. D.K. Das, the learned counsel for the petitioner, listed on 1/10/2024.
Obliged, Lordship.
Yes.
Fix on 28, madam.
Please come.
My lord, some matter is pending, so this may be kindly fixed on 29, madam,
Which matter?
regarding my land compensation, madam.
Which is land compensation?
Yes.
Which matter?
Madam, it is not mentioned, in the, not in the course list, but I'm mentioning it, madam.
Which item?
Not it, unlisted, madam.
Oh, unlisted?
Yes,
Oh. When do you want it?
on 29, madam.
Okay, okay,
Much obliged.
okay.
May I, Lordship?
29.
Yes, Lordship, I beg to mention item number 35.
Yes.
Your Lordship, the leading counsel is not getting well, so it's not ready.
Who is
So
the
this-
leading counsel?
C. Modi.
C. Modi.
Your Lordship, this may be adjourned today,
Mr. Swenso.
maybe list after 35, list
Learned
after
counsel
3 weeks.
submits that Mr. C. Modi, learned counsel for petitioner, is indisposed and therefore seeks adjournment of the case for 3 weeks. Prayer is allowed, listed accordingly. Okay.
Obliged.
My lord, I would like to mention item number 13, matter may be list after 1 week,
1-3.
1-3.
You're the counsel for the,
Petitioner,
on the prayer of Mr. Swenso, learned counsel for the petitioner, listed after a week.
1 week. Most obliged.
May I please, my lord?
Yes.
Hello, I beg to mention item number 30, 31, 32. Lordship, on behalf of petitioner, I'm mentioning, my lord.
30?
30, 31, 32, my lord.
Yes.
My lord, this matter may be,
You're the counsel for the petitioner?
yes, my lord, I on behalf of Mr. A. Kashyap, Ave Kashyap.
A. Kashyap, okay.
Yes. So, my lord, this matter may be fixed on 16th of September, my lord. 16 or 17, my lord.
Mr. Katho,
My lord, I am in item number 31, my lord, contempt case.
so will it be okay?
My lord,
16, my lord.
Mr. So-and-so? Learned counsel makes a mention on behalf of Mr. A. Kashyap, the learned counsel for the petitioner, and seeks adjournment of the case on 11/9/2024. On 16,
Yes, my lord.
on 16/9/2024, prayer is allowed, listed accordingly. Okay.
Deeply obliged.
Yes.
my lord, I beg to mention, my lord, item number 33 also, my lord.
33.
My lord, here I'm instructed to withdraw the, my lord, the writ petitions, my lord. So therefore, my lord, may I praise, my lord?
Contempt.
No, my lord. Item
Contract,
number 30
contract.
Contract matter, my lord.
Ah,
Everything has been done, my lord.
so you are the counsel for the petitioner.
My lord.
You have instructions to withdraw.
Yes, my lord.
Mr. M. Kato, learned counsel for the petitioner submits that he has instructions to withdraw the writ petition. Stop. The writ petition is accordingly closed as withdrawn.
My lord. They've left it.
My lord, may I beg to mention one WPC 435 may be listed for tomorrow, my lord. This is pertaining to withdrawal, my lord. Item number, sorry, 435 back, WPC, my lord.
Okay,
This may be listed tomorrow, but this is for withdrawal, my lord.
okay.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 24 and 25. On behalf of the come to your lordship. Kindly matter will be fixed tomorrow, your lordship, your lordship.
24, 25.
25, your lordship.
Okay. Tomorrow, no. We'll list it on Wednesday.
On Monday, your lordship then.
Monday, we don't have SB, we have only DB. Oh, Monday is Chutti.
Oh, yes. On Tuesday or Lordship?
Wednesday. Wednesday.
Your Lordship, I beg to mention item number 7. I'm appearing on behalf of Digi Pangim.
Item
7.
7. Yes,
He's out of his station.
adjournment.
Yes.
Mr. So-and-so, Learned Counsel makes a mention on behalf of Mr. D. Panging, Learned Counsel for the petitioner and seeks adjournment of the case for
2 weeks.
2 weeks. Prayer is allowed, listed accordingly. Okay.
I beg to also mention item number 8.
Item 8,
On behalf of Kemo Lolen.
on behalf of
Kemo Lolen.
Kemo Lolin. Only change the name, ma'am. Kemo Lolin. Okay. Same, after 2 weeks.
Okay.
Okay.
Lordship, I'm sorry, in item number 24, 25, there is interim, implementation.
Item 24, 25. 24, 24, 25, 24, 25. The interim order passed earlier shall continue till the next returnable date.
Much.
Okay. Yes.
May I, Your Lordship?
Yes, ma'am.
Lordship, I am before this honorable court seeking WPC number 147 of 24, Your Lordship, that this matter may kindly be listed for 27. It's an unlisted matter. This prayer is on behalf of M. Biswas, Your Lordship, outstation counsel.
It will be earliest 28.
He prayed that if the matter can be fixed on Tuesday,
No, 28.
Otherwise,
It will be
Wednesday,
earliest
Your Lordship.
28.
Wednesday, if it is possible, Your Lordship.
Wednesday, that's why Wednesday is 28.
27th, Tuesday, Your Lordship.
27, no, 27.
Then otherwise Wednesday, if
Wednesday, that's why I'm
Yes, Your
giving you Wednesday 28.
that would do.
Yes,
Much of.
28.
May I please, my lord?
Yes, please.
I beg to mention item number 5 and 6.
Yes.
Lord, I'm appearing on behalf of Opada.
Oh, Pata.
And
Oh.
in this matter, my lord, we are for the petitioner.
Yes, yes.
Matter may be taken up after 3 weeks. And my lord, consent has been obtained from other side.
Okay. Mr. Essential Learned Counsel makes a mention on behalf of Mr. O. Pada, the Learned Counsel for the petitioner and seeks adjournment of the case for 3 weeks. Prayer is allowed, listed accordingly. The consent of the respondent has been obtained.
Lordship, I beg to mention item number 4.
Item
Number 4. I am for the petitioner. I beg
this motion item 4.
yes, Your Lord.
Okay.
The leading counsel is out of station.
Uh,
So I beg your lordship to list this matter on Wednesday of this month, next
28.
next week, yes,
Item 428.
oblige you.
Okay.
Your Lordship, I beg to mention item number 29. Your Lordship, I'm for the petitioner. Your Lordship, in this matter, the petitioner don't want to pursue the case further, so I want to withdraw this case. So,
Ma'am, you are the counsel for the petitioner.
petitioner, yes.
Your good name?
M. Likha,
N. Likha.
yes.
Your item 29. Likha Moriam.
Yes, yes, Lord.
Okay. MS Likha Moriam. The Learned Counsel for the petitioner submits that she has instructions to withdraw the writ petition. The writ petition is accordingly allowed to be withdrawn. Okay.
Deeply ordered.
My lord, item number 1, my lord, although I sought for the relevant records, my lord, I could not obtain, my lord, as the officer concerned, my lord, he's out of station, my lord. I'll need 2 weeks' time, my lord, to obtain. It's from other district, my lord.
Hope you are not giving to the release order dated 7/8/2024.
My lord, I've told them, my lord.
If
And-
not, they will invite contempt.
My lord, that's why I've already told them, but from the petitioner also, they might have taken a step, my lord, informing them matter. But from my side also, I telephonically
What is
informed.
your instruction?
Your Lordship, there is a clear violation of the order, Your Lordship, passed by this honorable court, Your Lordship. And as such, Your Lordship,
The release order has not been recalled.
yes, no, it has been recalled by the principal itself, but it was again cancelled, Your Lordship, on the remarks that the principal does not have the authority to cancel the release order.
Okay, so we call the officer concerned. We asked him why he has not recalled this release order. We asked the
Your
officer to
Lordship,
come.
regarding this order, Your Lordship, I have also find a contempt against the respondents, Your Lordship.
It's a pure case of contempt, just
My lord,
before drawing any contempt proceedings.
my lord,
We would like to give him an opportunity,
My
at
lord.
least asking him to explain as to why the release order.
And
my
Your
lord,
Lordship,
maybe there might be some communication gap also, my lord. I don't know as of now position, my lord. Because I already on telephonical, I'll inform them and also requested them to take necessary statement. And from petitioner, also, I believe that, my lord.
no, Your
No, we
Lordship.
call the officer.
My lord,
We call the officer, let him explain whether he has recalled the release order or not.
my lord.
Okay.
Your Lordship, if I may, Your Lordship, I may be allowed to make submission, Your Lordship. This one, Lordship, on dated 7, Your Lordship, this honorable court has passed the status quo order, Your Lordship. And then, Your Lordship, the same was, Your Lordship, violated by the principal. But on 12th of, Your Lordship, on the next date of hearing, Your Lordship, we, by the prayer of the learned standing council, Your Lordship, this court has, Your Lordship, Your Lordship, in here, order dated 12, the learned council, Your Lordship, due to difficulty, he could not contact the concerned officers in the district. So by that, Your Lordship, this honorable court has considered, Your Lordship, and did not contempt, Your Lordship.
The release order was already statement.
Where are you serving now?
Your
Are
Lordship,
you serving in government higher secondary school, Hayilang?
yes, but I am not allowed to join my duty, Your Lordship. I am not allowed to discharge my, I am being debarred, Your Lordship.
What is the fate of this 7/8/2024?
That has not been complied by the competent authority, Your Lordship. Whereas, Your Lordship, in the order dated 12, it is clearly mentioned, Your Lordship, if I may, Your Lordship, in here, Your Lordship, status quo order passed earlier shall continue till next date, Your Lordship. And in para 2 of the order dated 12/8, Your Lordship, it is clear that while permitting the petitioner bringing such documents on record, considering that status quo was operating, it is provided that the release order dated 7/8/2024 shall not be given effect to. That has been violated by the.
Okay, that means you are still serving in that old school.
I
are
ought
still
to have been
serving in that
serving, Your-
school.
I should have been serving, but I am not allowed to join my duty, Your Lordship.
My lord,
Whether what is the fate of your transfer to government upper primary school, Dingliang, Anju district? What is the fate of that order?
my lord, he's not there. He's in Hailong only. My lord, that
Yes, of
release
course.
order has not been given effect as per the order of this honorable court, my lord.
Yes.
Where he has not been, he's there only, my lord. He has not even joined there at the upper primary school, my lord. Then there's only communication gap, my lord. When the release order has been not directed to be not given effect to, my lord, it is there, my lord. It's not a case he has been forcefully been transferred the present place of posting, my lord.
You take instructions and come.
My lord, my lord.
You take instructions.
Your Lordship,
Why as to why he is not allowed to join
My
the
lord,
school?
my lord,
Okay.
Your Lordship, if I may, Your Lordship, the fact of the case, Your Lordship, after filing of this instant writ petition, Your Lordship, when this order court took cognizance of
Too much of submission is also not good for you. Maybe let him get the instructions and come.
Your Lordship, I humbly, Your Lordship,
Okay,
submit
you
that.
got necessary instructions? Okay,
yes, my lord,
as to why he is not allowed to join the school.
my lord, my lord,
Okay,
my lord.
on the next date fixed. Mr. Your good name?
My lord, T. Tagum, Tabatagum, Standing Council Education Department.
The Learned Standing Council Education Department. As to whether the release order dated 7/8/2024. has been given effect to? And as to why? The petitioner has not been allowed to join the government higher secondary school higher law. Okay,
My
you
lord.
come with this two specific instructions. When can we fix it?
Any day.
My lord, can you do 30, my lord? We'll try, my lord.
30.
My lord.
Your lordship, I would like to, last year, your lordship, I humbly submit, your lordship, that before the interim was, your lordship,
Listed on 38/2024. Yes.
oblige your lordship.
Yes, Mr. Tara, what is the good outcome?
My lord, financial bid open. Moreover, the petitioner number one,
Petitioner,
who also swear the oath. He is-
petitioner number 1.
Ah,
He is what?
he
He has also been selected.
he is representative of the one of the farm,
He is
one of the
represent-
unsuccessful farm.
He is the representative of.
Representative of one of the unsuccessful farm. He is interested party
Okay.
in the farm, tender process. His telephone number. This is the documents. Telephone number given in the petition is also said. It's a Tassedar.
Petitioner number 1
Yes.
is the representative of the unsuccessful bidder.
Unsuccessful. This petition is only because they could not get the work. So
Yes, Mr. Tara, you seems to be a shadow petitioner.
yes.
Yes, my lord. Well, in the scheme of so many hustle and bustle dust, things are like to happen like this. And as a counsel, as an officer of the court, my lord, unless the client don't discloses us, we are blind. Just like a law is blind, so we are also blind and the blank. And which, if that is the case, so my lord, then name of this petitioner may be striked down.
Petitioner number 1.
He is the person.
Unless you file an application, we can.
Yeah,
just
That
take it.
cannot be, my lord. Like, even then, my lord. Well, the basic instruction which my brother was asked to call for, and I know my brother Tarak is very kind to the magistrate, my lord. He has always had
Yes.
that feeling of the society, and then which, my lord, put him a simple question. Don't you have a respect for the community sentiment? And you are trying to take out the land forcefully. So that is what the mighty grievances before my lord is. My brother should also understand, if you are trying to fish in a troubled water, naturally many things will come out. Say, suppose, my lord, today my brother might take a question of law, that these, that. But at the same time, this matter is going to prolong if any of the petitioner goes to the civil court, which we don't want. We want a respectful solution to an extent.
If their land is affected, let them go to civil court.
That's why, my lord.
It's always open for them.
I made a very humble submission yesterday. I said, my lord, we want the road also, but at the same time, respecting the community lands and ownership, my lord, unlike every tribal lord. Therefore, this has to be taken care of. And I made a small prayer saying that since you have violated 6.12.
Mr. Tara,
my lord.
Your petition is also defective for non-joinder of parties. Financial, technical bid open, financial bid open.
My lord.
Now,
My lord.
there are successful bidders.
My lord, it can be under 226, my lord knows better than me. Under 226, my lord can touch everywhere by molding the relief.
No, it's all right. By molding the relief should be not just general like that.
No, my lord. I'm not.
It should be molded in such a way that the necessary parties are before this court.
Equity has to be balanced. So, my lord,
Mr.
my lord,
I want to help you out, but
my lord, only Only that why I said so, that equity has to be balanced. See, kindly see, the innocent villagers are going to suffer. And simple thing, we are nothing against the tendering process, nothing. What we are saying is kindly take our consent, So therefore, only our representation may be disposed of, so that government will take a decision. At least 7 days, within 7 days, we will submit, within 15 days, government will take a decision. If the answer is negative, then we will not make any comment, or we will not come back before the court also. Only to that extent, which my brother.
My lord, there was already one writ petition number 99 of 2024 filed by so-called forum.
The same forum.
Vibrant Village Program Land Affected People's Forum from the same area. They have filed writ petition saying that this is our lands. It's going to occur without acquisition. Subsequently, they withdraw the writ petition. And this particular project, which is before this honorable today, was also here in this writ petition. Parties are not there, but package, it was covered. Vibrant Village Program project was challenged by this writ petition 99. So subsequently, after election, they withdraw. This is nothing but fighting between two political parties. Even if inquiry held tomorrow also, it will find out. Like, if one party get a contract, other party will come to the case. Otherwise, villagers are only they are going to.
Yes, Mr. Tara, I think.
Without going into the merit or legality of the case, kindly direct the respondent authority to dispose of our representation. That would be the safest thing.
No stay.
Already parents will be open no.
We are not going to issue any direction.
Yes. My lord, only make a small observation. However, if the work has not been awarded till disposal of the representation.
Again, if we go to the representation, entire handwriting signature, it seems to be done by one or 2%.
No, that is another thing. You go to FSL. There is another.
From naked eye also we can.
Where is your representation?
Representation is at
31.
Page?
Page 31. Annexed 3,
page 31.
Page
31.
31.
31, 43.
33 to 34, there is handwriting.
It starts from 38. That
Yes.
type copy or
It is representation starts from 31. It starts from 38.
no, it starts from
31.
31.
Yes.
31.
From 33, there is handwritten. 33, 34.
And this representation also.
We direct for disposal of this representation without any condition.
Yes.
Okay. Because now financial bid, technical bid, everything is open. Now we cannot tell the authorities not to go ahead with the work order.
Well, how this financial bid was open is because of the advice given by my brother.
No, it was on 20. Data come up yesterday only.
No, we filed the read petition.
No.
He comes to know that no, I should
No, my lord, that's.
give advice so that making this read petition in fractures.
Where is that financial bid?
Yeah.
In the other cases you have given me, but not in this case. Financial bid, do you have a copy? Just,
Yes.
just for once. Yes, so we passed the order in December, but we are only giving a direction to dispose the representation within a specific period of time.
Publish.
No other conditions. Kindly note their names, okay?
Much obliged.
Yes.
My lord, the matter before the lordship is pertaining to the centrally sponsored scheme. The NIT issued by the capital division. So my lord, kindly come to the NIT in page number 35.
Page number
35, my lord.
31.
35, my lord. This is the impugn NIT, my lord. The first, here, my lord, the executive engineer, capital division A, PWD Arunachal Pradesh, Itanagar, invite on behalf of the governor of Arunachal Pradesh, invite on the online tender which such and such in the two which system technical and financial from the registered contractor in the category of class A, class 1AA, APPW or the equivalent class of the category of building and capacity as per the APST contractor enlisted in the
Okay, this is the NIT issued by the executive engineer.
NIT and lordship, this is issued by the
Capital Division A for the construction of State Cancer Institute. at Itanagar,
construction
Arunachal
of
Pradesh.
establishment of the Cancer Institute at
Yeah, what is the grievance?
Itanagar, my lord.
What is the
Whether
grievance?
this is the so my lord, this NIT is my lord encroach of the my lord the capital Doimuk division. This should not have been issued in the capital division. So in this regard, my lord may kindly come to the
You mean to say that this should not have been issued by the EE Capital Division A?
my lords, because my lord may kindly come to the page number 54.
Yes, wait.
So for the my lord, the capital region is concerned, the capital region has been divided into my lord four division.
Yes, which is the next relevant page?
54, my lord.
54.
My lord. The original one is in 53 and the 54 is type out. 54, my lord. Here, my lord. This is the office order dated 25 November 2019. In the interest of the public service and for the effectiveness and the smooth functioning of the division, the works jurisdiction of the four division under the capital circle shall remain in force as per under mentioned area immediately affects till further order. So this is the existing office order, my lord. This capital division A, which is my lord.
The boundary of the jurisdiction of capital A has been explained.
So this capital A jurisdiction,
My lord.
capital division A, capital division B, Naharlagan division.
And
Doimuk
Doimuk division. I will take the lordship to this both capital A and the, I'm not concerned with the capital, division B and the Naharlagan division. Now the dispute is between the capital division A and the Doimuk division. The work including the repair and the maintenance works, bridge and the building, etc. of the capital city under the 13th Itanagar Legislative Assembly constituency fall in the northern area of NS National Highway 415 from past Chimpu end to the bridge over Papunala, Naharlagan end and bordering 14 Doimuk Legislative Assembly constituency along with the Papunala of the northern bridge as is case map. So my lord, this is very clear that bordering with the Doimuk 14 Doimuk Legislative Assembly. Now 14 Doimuk Legislative Assembly is fall within the Doimuk division and this capital division A is fall within the 13 Itanagar Legislative Assembly constituency. Mal. Now, my lord, come to the Doimuk.
Why this capital division A mention is also made about Doimuk Legislative Assembly constituency and Doimuk division also? What I don't understand.
My lord, this is bordering 14 Doimuk Assembly constituency.
Bordering.
My lord. Meaning, my lord, border with the within the my lord capital region, there is two legislative legislative assembly constituency. My lord, this 13 and the 14 legislative assembly constituency. So capital division A fall within the 13 legislative assembly and at the present site for the establishment of the Cancer Institute is, my lord, within the 14 Doimuk Legislative Assembly. Man. Now, so for 14 Doimuk Legislative Assembly.
So what you mean to submit is that the establishment of the Cancer Institute is within the jurisdiction of Doimuk division.
My lord. In this regard, my lord, I'll take the lordship, kindly the lordship, come back to the page number 47, my lord. Initially, when the center has sanctioned, my lord,
Just wait.
now my lord, page number 47. Kindly come back to page number 47, my lord. My lord, got it? Here, my lord, land ability of the land. Here, my lord, 38.9 acres of the land is under the occupation of the health department of the Mitpu Papumpara district, which is around 4 kilometers away from the state loan medical streams as well as by the road in applied services around shall be used for State Cancer Institute. And my lord, kindly come to the next, my lord, 48. This is the geotax. The geotax was, this was, my lord, conducted by the department and geotax report has, my lord, finalized, whereby located in the Doimuk, my lord, showing the latitude and the longitude of the concerned area. And my lord, may kindly come to the next page. Now the site has been finalized by next page. This has been, my lord, inaugurated by the Honorable Minister of Health and the Family Welfare, Government of Arunachal Pradesh, my lord, in page number 49. This is site 4, my lord. This was done on 29 June 2024, my lord. Thereafter, my lord will find in the page number 50.
This is in Mitpu.
My lord, Mitpu is within the Doimuk, my lord. Now in page number 50, my lord. Now, in view of this, the government has finalized and the news was viral. And accordingly, my lord, on the parts line itself, Arunachal Center sanctioned arrest 217.19 crore for setting up of Cancer Institute in Doimuk. My lord, Doimuk at Midpuman. This has been published, and secondly, this is brought in the page number 51 also, my lord, that below the photographs, my lord, the line where it is reflected. In the significant development of the healthcare in the state of Arunachal Pradesh, the Ministry of the Development of Northeast Region donor has sanctioned Rs 217.19 crore for the establishment of the State Cancer Institute at Midpur Doimuk, Itanagar Capital Region.
What is page 55?
My lord.
What is page 55?
Then,
Page 55?
my lord. My lord, this is, in pursuant to this, my lord, this page 55 is the intimation submitted by the, my lord, executive engineer of the Doimuk. That, my lord, where in address to the chief engineer is the respondent number 4 before the lordship in the present case. Maintaining for the jurisdiction of the implementation of the scheme thereof, my lord. Here, my lord, the grievances from the Doimuk division has, my lord, addressed to the chief engineer Western June, my lord, respondent number 4, whereby, my lord, it is said that with reference to the above letter, it is to bring your kind notice that the work jurisdiction of the division within the capital circle PWD AP has been encroached. The superintendent engineer capital complex had issued the clear order directing the divisions of the maintenance of their own jurisdiction. Encroachment of the work beyond their jurisdiction has strictly been restricted. Enclosed order, my lord, these are the earlier order. That order, my lord, we have read about that the order pertaining to 26/11/2019.
What about 56?
My lord,
What
order
about
talking
56?
about 26/11/2019, whereby,
What about page 56?
my lord,
What about page 56? What is 56?
my lord. So, my lord, this is the reference, my lord. This is the second, my lord, this is the second time that the capital division A is encroaching, my lord. So this is reference that in the last 2023 also there was done, and accordingly, my lord, that complaint was settled by the page number 57, my lord, will find. This is issued by the superintendent engineer, capital circle PWD Arunachal Pradesh, my lord. This is the all in all for within the capital complex, whereby it said that, my lord, I will read out, my lord, in the second para. You are hereby adhere to order already issued wide number such and such that at 26/11/2019 in this regard to issue of the jurisdiction of the division. So the copy of order enclosed here, my lord, this is the copy, the order as, my lord, we have already read out. So this has been already settled in 2023 that there should not be encroachment of any jurisdiction while working, my lord, while issuing the NIT, my lord. Therefore, my lord, this NIT is impugned on the ground.
What is page 59?
My lord, this page number 59 is continuation in reaction to the letter of the page number 58, wherein, my lord, this page 59 said that with reference to the subject number such and such, my lord. Here, my lord, the proposal was tried to match that the satellite cancer hospital may be included, but the page number 59 is the reaction from the director of the health service that wherein, my lord, each stated itself, my lord, the government has already received the AFS for the establishment of State Cancer Institute at Itanagar, Arunachal Pradesh. So, my
Why there is encroachment of jurisdiction?
My lord, of course, there seems to be some encroachment of.
Of course.
But whether the dispute between these two divisions, executive, that affects his right, madam, petitioner's right, madam. The tender is open tender of 214 crores. The petitioner is eligible to participate as a contractor only up to 30 crores from his enlistment itself.
Oh,
My
you
lord,
are
we
not
kindly say-
eligible.
my lord.
Yes.
For that also, my lord, I am checking.
You are not eligible.
My lord, I have answered, my lord.
Where is your locus to
Let
find
him, my
this?
lord, let him finish first, my lord, I have answered.
My lord would
Huh?
say, page 17, my lord, it's enlistment of the petitioner, my lord. It is class one
Yes.
BNR,
Enlistment,
terms and condition, serial number 1,
30 crores.
30 crores.
You are eligible to undertake works
Up
only
to
for 30
30
crores.
And my lord, he has made.
Then
a
let us see
statement
the NEET, NIT, let us see that.
at page 35, my lord,
That page,
35.
this is for estimated cost of the tender project is 214 crores.
Yes,
2 crores,
no, my lord,
No.
214 crores.
214
14
crores.
That's
Rupees
why,
214 crores.
my lord, her
Yes.
eligibility is class 1 BNR. And as per the tender, it is class 1 AA,
Plus
1 AA.
where
In the
does it-
third line, my lord, registered.
category of
contractor-
class 1A.
Yes,
1
1
AA.
AA.
What is APPWD?
This is Arunachal Pradesh Public Works Department, my lord. This is the.
In
under
the
whom-
category of 1AA.
Yes, my lord.
You are in which category? Class
see,
1
class
or
one,
NR?
BNR,
BNR.
yes.
Mr.
My lord.
And I assume he'll make a submission that he is not being allowed to form a joint venture also, my lord.
No, that is not an issue here.
He is,
That is the my lord,
That-
the
that
first
is not an
aspect
issue here.
is pertaining
lord.
to the my lord encroachment. Now, my lord, may kindly see my second aspect of. the
You
challenge
are, what
is-
you are saying is that
is, my lord,
by executive engineer,
and my
by the
lord,
executive engineer issuing this tender, it has widened the area for participation.
yes, my lord.
now, my lord, second aspect, my lord, kindly.
No second aspect unless you satisfy this court.
My
on
lord,
this.
my
No
lord,
second
I
aspect.
am ready to demonstrate, my lord, that this is in the record.
You
My
first
lord,
come
may-
here, first come here.
Yes, my lord.
You
Kindly
are,
come.
you are a contractor who is eligible to undertake work only up to 30
My-
crores.
That is why I am challenging, my lord. The jurisdiction is parts issue. The second issue is, my lord, the condition given by the, my lord, this NIT is, my lord, class 1 AA. Now, so far the state of Arunachal Pradesh is concerned, my lord, this is hardly 1 and 2 contractor will be there, my lord. For the interest of this only, my lord, this specifically, this NIT has been called. For this purpose, my lord, the Union of the Ministry of the Road and Transport has already issued the guideline, my lord, while issuing the NIT. So, my lord, the guideline has been, my lord, violated. Wherein the guidelines say that, my lord, there should be a joint venture, my lord.
No, the first and foremost question is when the estimated the work is 214 crores and you are eligible to undertake work only up to 30 crores. What
Exactly.
is your right?
Exactly, my lord. Because,
Exactly means
my lord, because this NIT has, my lord, intentionally, my lord, joint venture violated the, my lord,
no.
guideline, my lord. My lord, for my satisfaction, my lord, may kindly come to see the guideline, my lord. What the
I am not seeing
guidelines say?
anything. You first satisfy me on this.
Yes, my lord. Guidelines say, my lord, there should be a joint venture, my lord. So joint venture has not been categorically, my lord, not given in this NIT, my lord. What the NIT said that the joint venture are not allowed. So my question is, my lord, why joint venture is not allowed? If joint venture is not allowed, my lord, none of this person will be qualified. Particularly, pertaining to the Arunachal Pradesh district-based entrepreneur is concerned, my lord.
Sir,
This
this,
has been
this
segregated.
petition has been filed. You have filed this petition in
Yes,
your
not-
capacity as the
yeah.
proprietor of this
Not as a joint venture, my lord.
Now,
as the proprietor of
my,
this
my lord, kindly. my
Ningla
lord,
infrastructure and power project.
Yes, there is no
Look
joint
at the,
venture,
my
my
lord,
lord. How can
guidelines.
he maintain? He has not,
Guidelines.
We are dismissing your petition
he has not even made a joint venture.
on maintainability. Just 2 lines.
No, my lord. My lord may kindly see the guideline. The guideline is clearly said that there should be,
I am not willing to.
there
listen.
should be, my lord,
Unless you satisfy.
joint venture. But the joint venture has not been included in this
Okay,
NIT, my
we pass the order in the chamber. Okay.
My lord, one thing, my lord, ordered, my lord, otherwise, my lord, my lord,
You withdraw and come up with something where you can show that you are eligible. Here
If
you
my
are
lord,
not eligible.
if my lord, at least allow me to, my lord, demonstrate what
No,
is
no,
the
no, no,
joint
no,
venture.
no. You first satisfy me on that ground. If not, we are dismissing
Otherwise,
your.
otherwise, my lord, the representation placed by the, my lord,
No,
is
no, no, no representation, no.
executive engineer is, my lord, pending. If my lord come to the
No,
page
no,
number
no.
55.
I thought the issue of jurisdiction between these 2 engineers, Duimuk and Naharlagan.
That is
I
the
think,
part aspect, my lord.
that issue might have supported you, but you are not eligible.
I am not eligible. That is why, my lord, I am challenging this NIT because this NIT has, my lord, purposefully, my lord, called for
Record the names.
denying the
Record the names. We pass the order.
violation
Just
of
2 lines
the
order in the
NIT.
chamber.
Always, man.
Guideline.
Yes.
All
We are dismissing.
My lord, my lord. So, my lord, in such situation, I may be allowed to withdraw liberty, my lord. I may come with it, my lord. Despite of my lord, dismiss, my lord. I am praying for my lord, liberty to it.
You make many submissions, but when you are not qualified, when you are not eligible, you cannot take this court round and round and round. You hit the point, then maybe we give you relief.
With liberty, my lord. I may be allowed
Mr. So
to.
and so submits that he has instructions to withdraw the writ petition with liberty to file afresh. Prayer is allowed. Liberty is granted to file afresh. No problem. No. You kindly record the names, no? Yes. No need. We have passed the order.
My lord, may I please, your lord,
Yes.
this matter pertaining to ex gratia of
Where is your affidavit in reply? You have on many occasions prayed to file affidavit in reply there. Now you want to argue.
affidavit in reply. Oh, yeah.
Where is status file?
Extremely
Status
sorry,
file.
my lord. It is prepared, but due to
It is prepared, then file it.
I forgot.
My dear friend,
Yes,
you file it. We'll hear you.
Yes, my lord. Sometime maybe.
How much time?
2 weeks.
2 weeks.
Yes.
Mr. So-and-so, learned counsel for the petitioner is allowed 2 weeks time to file affidavit in reply. Listed accordingly. Okay. Yes.
My lord, since the petitioner not turned up, my lord, in this case, my lord, there's subsequent development, my lord.
Okay.
Now, this is regarding, my lord, the merger of the ZPC, my lord, and Jila Parishad member of the Papumpara and Jila Parishad chairperson, my lord. So there was the merger from one party to another, my lord.
Okay.
Now, subsequently, the basic, the main, all the petitioner, most of them, they are from the BJP. Now, subsequently, there was a expulsion, basing on which, my lord, disqualification was done, and disqualification order, it has been, the complaint has been passed in favor of this respondent, my lord. They have not been disqualified by the competent authority. But again, that order that challenge. Now, subsequently, during the pendency of the petition, the party, they have recalled the expulsion order. Practically, it's become infractions. So we may require to, since it's not there, we may require to bring it to record that subsequent development by way of additional affidavit.
Okay.
This may be listed.
You are for the, who is for the petitioner?
Absent, my lord.
You are for the?
I am for respondent, my lord. Respondent.
Respondent?
1 to 14, my lord.
1 to?
No, 1. 4, my lord. 4 to 12. And 13, 14.
Respondent number 4 to?
14.
4 to?
4 to 12 and 13, 14, my lord.
4 to 12 and? 4 to 12 and?
4 to 12, 13 and 14, my lord.
13 and 14.
Yes, ma'am.
4 to 12
Petition.
and 13 and 14. So 4 to 14.
Yes, ma'am.
Then 15?
I'm appearing on behalf.
15. And Mr. Tapin?
I'm for 153.
Okay, so it will not be necessary for you to file affidavit? Not required.
Based on decision only.
Okay.
Appeal.
So it is on you to file affidavit.
My lord, only additional affidavit, ma'am.
Yes, to bring the subsequent developments. on
My
the
lord.
Mr. So-and-so. The learned counsel for the respondent number 4 to 14 submits that he may be allowed 2 weeks' time to file additional affidavit bringing the subsequent development on record. Prayer is allowed, listed after 2 weeks.
My lord, let him 3 weeks, my lord. After 3
3
weeks.
weeks, okay. After 3 weeks.
हो जाएगा, हम देख लेंगे.
The short question involved in this writ petition is that settled seniority has been unsettled. The petitioner was appointed in the year 2008 by the Director Economics and Statistics, Government of Arunachal Pradesh. Then he was posted to Zero District Planning. Then in 2012, he was again transferred back to the directorate. And the seniority was casted. And the first seniority list, provisional seniority list, I stands at serial number 1, while the private respondents are at serial number 2 and 3. That is, my lord will find that seniority list at page 26 and 27. Then thereafter, my lord, what had happened? The provisional seniority, then that impugned seniority list was published on 7/6/2023. That is at page number 31.
Yes,
then there I was placed at serial number 3, my lord. Now the question comes, my lord, whether a settled seniority can be unsettled. That is in terms of, my lord, kindly come to page 26 for a moment. My lord, I address my lord from the appointment order itself, so that there is no ambiguity left.
Page 26 is the provisional seniority list.
Yes, sir. Before that, my lord will kindly come to page 21, my lord, my appointment letter. From there, I'll demonstrate, my lord. Only
Unskilled contingency stuff. Unskilled contingency stuff.
Correct.
Whether these are regular employees.
No, my lord. Then, according to RR, my lord, there is some reservation for.
Mr. Tara.
My lord.
Yes, for my knowledge.
Yes.
Why is the seniority maintained for this unskilled contingency?
Seniority is maintained, my lord, for regularization.
For regularization.
Regularization.
Okay.
My lord will kindly come to paste on.
So there is a practice that the senior most is a regularized person.
Correct. My lord, I demonstrate from my appointment letter itself page 21.
Page
21. That is 3rd September.
Just wait.
Miss so and so on
Just
the
wait. Let me get it. Page
21. Yes. Miss so and so on the present PS is coming is hereby engaged as full-time contingency paid worker unskilled at a fixed monthly wages at the rate of so and so only per month under the Directorate, my lord will mark this, under the Directorate of Economics and Statistics, Government of Arunachal Pradesh, with effect from the date of her joining up to 31/3/9 and attached with district. Word attached, my lord. This, there is a confusion. The other side will also take the same ground. That why? Because my lord, see, my appointment is done by the director. Then I was attached with the district statistical officer 0, my lord.
First, Mr. Tara.
My lord.
First, lead me to that scheme.
That
lead me to that scheme where you show that the senior most.
Yes, ma'am.
Is regularized first.
This
No, I just want to see
that
the
scheme, my lord. They're in the recruitment rule itself. My lord will come at page 34.
Page 34. Notification.
Yes. Is a rule, my lord will kindly come to schedule, my lord. My lord.
Do you this
Page 36, page 30.
This rules.
Correct.
This rules may be called the Arunachal General Arunachal Service Rules.
Correct, my lord.
Ministerial multi
Tasking.
Daftri Pion Chogidar Mali.
Earlier, my lord, all the unskilled.
And these are for contingency fixed pay also.
Correct, my lord.
So which is the relevant?
The scheme is at page 36, my lord.
Page
36.
34, 36.
Schedule 10, my lord. Schedule 10. My lord, A is not relevant to us. B is relevant to us, my lord. 50% of the vacancies.
Yes. Where are you reading page 36?
Page 36, my lord. Schedule 10.
36.
Column 10, my lord. Column 10.
Method of recruitment.
Method of recruitment. Column 10. A is not important to us, direct recruitment. B is important. 50% of the vacancies shall be filled up from amongst the existing unskilled contingency staff who have completed 15 years of service and who possesses educational qualification of class 10, stroke ITI or equivalent pass certificate from a recognized board or the institutions. The selection shall be done by the Arunachal Pradesh staff. Now all the recruitments are done there.
This is on the basis of merit?
Yes, seniority.
No, not yes. Seniority. This is on the basis of merit.
Correct, madam. Seniority will come then. When there is a merit, my lord, seniority also comes into force.
You actually qualify 15 years of service.
Correct.
You are class 10.
Class 10 pass.
What is this ITI? Is it alternative?
This ITI is well, there is an institute which Industrial Training Institute, my lord, that gives a trade test, my lord. So,
no, whether you should one must possess this qualification class 10 as well as ITI.
This is disjunctive. This is disjunctive. Slash ITI is equivalent to class 10 pass. But then, my lord, what had happened? This scheme was further amended on 13th July 2021, page 38, my lord.
38.
Page 38, my lord, 38.
This was amended.
Amended, my lord.
This was amended by this page 38.
Page 38, my lord. 50% to, my lord, column 10 of para B was
Yes.
amended further. Page 38, my lord.
Page 38. I'm
Serial
there.
number 2, my lord.
Which para?
Is para 2, my lord. Amendment to the schedule of the principal rules.
Para?
Para 2, my lord.
Amendment to schedule
Yes.
2 of the principal
Yes.
rules.
In schedule, or is better, my lord, schedule it is. We call it as a schedule in the pronunciation. In the schedule of column 10 of para B, for existing para, the following shall be substituted. 50% of the vacancies shall be filled up from amongst the serving unskilled contingency staff, auxiliary labor corps, casual laborers with minimum 15 years of continuous service in their respective offices, department, and possessing educational qualification of class 10 stroke ITI or equivalent pass certificate from a recognized board or institution. The selection shall be made on the recommendation of the departmental promotion committee on the basis of seniority and performance. Now this has been changed, my lord. So here, now my lord will kindly see two things, my lord. Kindly come back to page 26, my lord. The first provision, 26, 26, my lord. Annexure 3, my lord. This was casted, it was issued on 28th March 2018. Now the provisional seniority list as on 20 February 2018. My lord will kindly flip.
As on?
Yeah, as on 28 February 2018. My lord will kindly flip over to page 27. Here, my lord, I figure says serial number 1. I joined on 6/10/2008. The private respondent number 1 joined on 24/3/2011. Then the private respondent number 3 is at 5/5/2012. Now, accordingly, my lord, what had happened? Then further, it was again this seniority, provisional seniority list was recasted on 8th September, which my lord will find at page 28, my lord.
Page
28 to 8, my lord.
28.
Yes. Provisional seniority list in respect of unskilled contingent staff under the establishment of Directorate of Economics and Statistics, Government of Arunachal Pradesh, Itanagar. After thorough examination of all the claims and objections, the stroke representations received from some staff and after, I need not to read this, kindly come to page 29 straight. This is how they have recasted the seniority list, my lord. Now here, my lord, my seniority has been reversed. Now, the private respondent number 1 is has been made senior to me, then 2 also has been made senior to me, then I'm relegated to 3rd in the seniority list. Now, my lord, the question is, simple question. Then I submitted my representations, everything there, citing that this reasons, but then still they are sitting, saying that, no, since you have come back from 0, but I am contending that my appointment has been made by the directorate. For administrative exigencies, you have transferred me to 0. Now I have come back on 2012 to the directorate. But then I have joined my services in the year 2008, my lord. Now, therefore, the question is, once you have settled the seniority list,
and then thereafter again you recasting, the question simply comes in service jurisprudence, my lord.
But the first one is the final seniority list, correct?
Correct.
And the subsequent recast is provisional.
Provision. So therefore, the concept is in service jurisprudence, my lord, once settled seniority should not be unsettled, my lord, whatever reasons it may be. My lord is aware in service jurisprudence, my lord, there is immense sanctity of final seniority list, my lord. List one published cannot be disturbed, my lord. That is the law, my lord. I place this particular judgment, my lord. Rajendra Pratap Singh judgment. Para 44 to 46, my lord. But the fifth is very important, my lord.
Para?
My lord.
Para
45, my lord.
para 45. Okay.
Internal page 754, my lord.
Yes.
We deem it appropriate to reiterate that in service jurisprudence, there is immense sanctity of a final seniority list. The seniority list once published cannot be disturbed at the behest of a person who choose not to challenge it for 4 years. The sanctity of the seniority list must be maintained unless there are very compelling reasons to do so in order to do substantial justice. This is imperative to avoid unavoidable litigation and unrest and chaos in the services. That is sum and substance of my case.
Have you impugned this provisional seniority?
Yes. The other side, my lord, what they will say that I don't know, but this is my case.
Yes, learned government advocate, what is the reason to dislocate the seniority?
Lordship, initially the petitioner was appointed, Your Lordship, against a vacant district quota in the district statistic officer under the establishment of Deputy Commissioner, Your Lordship, Lower Subansiri District, and not under the Directorate Economic and Statistic Office, Your Lordship. Your Lordship, the petitioner was appointed by the then Director Economic and Statistic, but she should have been appointed by the head of the establishment, that is Deputy Commissioner. There is an order, Your Lordship, that Deputy Commissioner.
Can you reg up that issue now?
Yes, Your Lordship, there is an order also, Your Lordship. And I have produced it before the.
The petitioner was appointed by the director?
Yes, Your Lordship. Order is there, Your Lordship, but it has to be by the.
Who is for the private respondents? Yes.
My lord, seniority is based establishment on the station is. There is no common seniority for all.
Then why actually this seniority at page 27?
District, they maintain separate seniority list, and the directorate, they maintain separate.
That's why in both the seniority, the name of the petitioner appears?
No, this is the seniority list of the Directorate Economic and Statistic, Your Lordship, not the zero, Your Lordship.
Not the
Lower Subansiri District, Your Lordship. She was initially appointed in the appointed in the District Statistical Office, Lordship, not in the Directorate.
Why this common seniority list for the petitioner as well as the private respondents?
Because in 2012, Your Lordship, she has been transferred from zero to the Directorate Economic and Statistic by her own request, Your Lordship. Otherwise, the post of MTS, Your Lordship, it is non-transferable.
No, actually, she should have been
She should not have been transferred, Your Lordship.
She should not have been mentioned. Her name should not have been entered in the seniority list.
No, since she has joined the Directorate Economics, so her seniority and the seniority is maintained.
Where is your ground? Where is your ground in your petition?
Lordship, I have produced one order, Your Lordship.
No, have you filed your affidavit?
Yes, I have filed, Your Lordship, and
where have
produced
you
one
stated?
document also, Your Lordship.
Where have you stated? Where is your affidavit?
Lordship, paragraph 6, Your Lordship. Page 4.
Whether the director has given a conclusive decision?
Yes, Your Lordship. That Lordship, in the common practice, Your Lordship, to maintain seniority, Your Lordship, they follow the date of joining, in the establishment, Your Lordship. That is how they maintain the seniority in the establishment, Your Lordship. And the petitioner, Your Lordship, she has joined the establishment in the year 2012, Your Lordship. Though her appointment is of 2008, Your Lordship. This is how they maintain the seniority, Lordship.
What is disturbing the mind of this court is why actually common seniority was maintained for the petitioner as well as for the respondent?
It is not the common seniority list, Lordship. The seniority list which she has annexed, Your Lordship, and even I have annexed, Your Lordship. It is the seniority list under the establishment of Directorate of Economics and Statistics, Your Lordship. It is different from the other district, Your Lordship.
How?
After her joining in the Directorate of Economics, Your Lordship, her seniority is at serial number 3, Your Lordship. And respondent number 2 and respondents 4 and 5, they are senior to the petitioner as per their date of joining.
Have you filed reply? They are actually seriously.
They are taking contradiction.
They have not
reply?
joined a
I'll
rejoined.
not file neither.
I think you will have to. If not, whatever they're saying will be admitted, will be deemed to have been admitted.
But there cannot be two seniority lists in single department.
No, they are on establishment.
No, my lord.
They are on establishment. So they have actually met that amendment in their affidavit in opposition. I think you must at least refute that. At least refute that, because actually if you don't refute, instead of giving you opportunity, it will be deemed that you have admitted whatever is stated in the affidavit in opposition.
All right, I'll file it.
Yes, I think that will be proper for you. Don't take chance. Because I was also in the government for about 14, 15 years. The government can really twist things. We give you file affidavit to your reply to both the affidavit.
Right.
Okay.
Lordship.
Mr. Titi Tara, the learned counsel for the petitioner is allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents, as well as by the private respondent number 4 and 5. Listed accordingly.
Interim order to continue.
Yes. The interim order passed earlier shall continue till the next returnable date.
My lord, this matter.
Yes.
The service report upon respondent number 4 is still awaited. So, Your Honor, I put a petitioner. 3 weeks time.
Yes, in the office note dated 21/8/2024, which shows that service report in respect of respondent number 4 is still awaited. Listed after 2 weeks.
Like.
Yes, what is your contempt?
My lord, I am filing my affidavit today itself, my lord. On
What, Mr. Mook? What was the direction?
direction is
Now, what was the direction?
direction was
Where is the order alleged to have been violated?
order is
This 22/9/2023.
order dated on 22/9/2023.
Yes, what was the direction passed in that?
And particular operative part is part 30.
Page,
Para 13 of the judgment.
you have not even paged your petition, your juniors.
No,
I
no.
think they're very casual.
No, this is in there. Court has taken the suo motu.
Pardon?
Court has taken the suo motu
Oh,
contempt. So even while the petition was filed, that time I was
suo
not
motu.
here.
There is no
Here,
page.
here, para 13, that being the position, a suo motu contempt proceeding be drawn against the Deputy Commissioner Eastern District, namely Tai Tagbu.
Where is that?
Para 13 of the judgment.
Where is that order 22/9/2023?
Yeah.
22/9/2023.
Huh.
What is in fact, it is whether impugn order dated issued by the commissioner shall remain state till disposal of the writ petition. Is it this order?
In this order in para 13. WPC number 452 AP 2023 dated 22/9/2023 and para 13.
Para
13.
Para
The
13.
judgment.
No para, nothing.
Para.
No para.
No, there is para in the judgment. Oh, say 17/11/2023.
You are on
17/11/2023. That's being the position a suo motu contempt proceeding be drawn against the Deputy Commissioner Eastern District, namely Tai Tagum, for willful violation of order dated on 22/9/2023. Passed in WPC number 452/2023 by this court. Accordingly, registry is directed to register a suo motu contempt and issue notice to the said Deputy Commissioner. Notice is made returnable after 4 weeks.
No, that's why I'm asking you, what was the order which is alleged to have been violated?
Oh, well, yeah,
Which is the order which is alleged to have been violated?
on the piece of the
Yes, Mr. Learned Counsel, have you complied with this order 22/9/2023?
Yes, my lord, I have already complied the order.
You have complied?
Yes, and I have filed also unconditional apology before Seniority.
Oh, so they have complied. So you have a, so you have stayed the order.
My lord, in my fault, I am not accepted the joining report of draft petitioner. That's the only.
I am very confused. What is the order alleged to have been violated? You first tell me that. What is the order alleged to have been violated? Because of which this suo motu contempt was drawn. You are appearing for the contemner?
Yes, ma'am.
Who is the contemner?
My lord, contemner is the Deputy Commissioner.
Only one?
Yes, ma'am.
Only one. What is the role of the Deputy Commissioner in the contempt?
Even in the writ petition, I was not.
Arey, bhai, how?
Five.
17/11/2023. 17/11.
Has the Deputy Commissioner allowed the petitioner to join the post?
Yes, my lord. After they joining the post, even the government again government passed another order, and he has been already released from the Eastern District.
He has been released from the
Eastern District.
Where is your affidavit?
My lord, I filed affidavit.
Okay, Mr. Mook, let him file affidavit. I think if the affidavit complies with the order, maybe we can take a linear view. Okay, so you file your affidavit, we list it on Wednesday next. Okay, Mr. Your good name?
Omodi.
So and so. Learned counsel for the sole container respondent
Yes.
submits that he will be filing the affidavit on behalf of the said respondent in the course of the day. Listed again on (28) 8/2024. Stop. A copy of the affidavit filed on behalf of the container respondent shall be furnished to the learned counsel for the petitioner. Kindly later accept. Okay, you accept.
Okay.
May I please, your lordship?
Yeah.
My lord, this is also a contempt petition, my lord. Contempt number one. Contempt number one has appeared and filed the affidavit, my lord. The direction was that, my lord, direction was that related to compensation of solution, my lord. I'll just take to the
Affidavit in opposition file on behalf of respondent number one.
one, yes, my lord.
And the same is placed on record.
Yes, my lord.
Then
Now-
who are the other respondents?
Now, respondent number 2 and 3 has to deposit the money to the deputy commissioner for disbursement, my lord. Now, deputy commissioner, respondent number 1 has verified the compensation
Yes,
and
please. Respondent.
my lord, content number is page 14, my lord. Page 14. Page 14 is
Just wait.
page 14.
Just wait. Yes.
Yes,
Which
my
is
lord.
that page?
Yes, I will just take to the operative person of my this one, my lord. Is in page 20. It starts from page 28, my lord. Page 20, married, my lord. In view of above, the read petitioner disposed of with direction to the deputy commissioner lower Debang village to verify as to whether the petitioner herein were paid the compensation pursuant to the notification such and such. Section 10 of the Balipura Frontier Zoom Regulation and issued by Deputy Commissioner Land Management, Government Partnership of the White for the acquisition of land starting from such and such point on only on any road, river bank or if you planning to 16-kilometer point. If on the verification, my lord, if on the verification made, it is found that the petition herein have been paid the compensation pursuant to the notification dated 29/7/2014 issued under section 10 of Balipura Tirap Sadhya Frontier Tracts Zoom Land Regulation Act 1947. Petitioner shall also be paid the solution as well as interest in terms of Act 2013, my lord.
Yes, Mr. Stoppin. Whether compensation has been paid?
No. The main compensation has been already paid.
Has already been paid.
Already.
Now it is the interest.
Solution
and interest, my lord.
Solution and interest in terms of 2013 Act. What is the fate of that?
Now, my lord, Deputy Commissioner has verified. It's in his reply, my lord, in page 64. They have verified. They have included the solution. They have included the interest, but then not yet paid.
Not yet paid by?
It is to be paid by the Deputy Commissioner, but then it has to be approved by the contempt number 1 and contempt number 2, and then it has to be deposited by contempt number 3. Because this project was under BRTF. The project was executed by the BRTF.
Who is the contemner 1?
1 is a Deputy
Commissioner. 2
Yes.
is?
2 is the Secretary Land Management.
Land Management.
Yes, madam. And then 3 is the BRTF.
Who has acquired the land?
The The land is acquired by the state government for the
Ah.
BRTF.
For the BRTF.
Yeah, well, and
So it is the BRTF who should pay the compensation.
compensation money. He has to deposit, my lord.
Yes.
Verification has been done by Deputy Commissioner, sent to the secretary and to the contempt number 3. Now the contempt number 3 has a deposit before the Deputy Commissioner for
Ah,
deposit.
the contender number 3 is not deposited.
Not yet deposit.
So who is for the contender number 3, the main culprit?
3 and 2, my lord. Not yet appear. Otherwise,
Not yet entered.
not yet enter, my lord.
Not yet entered.
Yes, my lord. But service is complete as per the judicial order dated 1/7/2024, my lord.
Thus, this service received, learned counsel for the petitioner has taken it, and accordingly. the
Your lordship may see
issued,
order dated 1/7/2024.
Divide, by justice service. Yes, now what should be done?
Now, service is complete, my lord. As per the judicial order dated 1/7/2024, upon the respondent number 2 and 3, my lord. They have received the orders, my lord. And the issue will be that why the contempt should not be drawn against the number 2 and 3.
We give them one chance.
Yes, my lord.
Lordship, I'll personally inform the respondent number 2, Lordship.
Huh.
The matter will be listed on Tuesday, Lordship.
Wednesday.
When it's no issue.
Let this matter be listed again on 28/8/2024. Okay.
Obliged.
Wait, please, Lordship. Look, this is also a contempt case. My lord, your lordship may kindly come to the annexure 1 of my contempt petition. Page 12, my lord. And operative portion is at page 14, my lord. The direction was issued to pay the pending amount of 10 crore 24 lakhs 88,680 within a period of 6 months. That has not, even after the lapse of 6 months, that has not been paid. So therefore, my lord, I have initiated a contempt petition number 8, which is I have annexed at page 18. Well, in that the secretary has taken a categorical stand that we have already taken the initiative from the government. Cabinet subcommittee has also approved, and it will be paid within a reasonable time. Accordingly, your lordship they have paid rupees 5 crore out of the 10 crore 24 lakhs. That also I have annexed. My lord,
What is the remaining amount?
5 crore.
At least government is giving you something.
My lord, yes. No, my lord, there was another contempt petition, IA. My lord, there they have taken a category statement that the amount will be released. So therefore, lordship was pleased to close that contempt by directing that it should be paid within 6 months. Now that has not been paid. And therefore, this contempt petition has come up. Now, my lord, in their affidavit, the respondent number 1 and 2, in their affidavit, your lordship may kindly come to paragraph 3 of their affidavit, my lord. Affidavit by the respondent number 1 and 2, my lord.
And what is this letter from the?
My lord, I'm coming to that. I'm coming to that, my lord.
But this is not proper. They are not supposed to write to the registry. They are supposed to file an affidavit through the government advocate.
My lord, here.
How the registry has accepted this?
My lord, here they have taken directly a contrasting in paragraph contrasting stand in paragraph 3. What the secretary and director of the concerned department says is that they have placed the requirement to the government, but the finance has refused to sanction the amount. And in this letter, the commissioner.
Madam, are you for the finance? Who is for
I'm-
the finance?
I'm for respondent number 3, my lordship.
Mr. Tapin, are you for the finance?
Very, my lordship.
Finance for the first time is appearing into. I think.
Today morning I filed my galat number.
Oh,
So
for
I will
respondent?
grant it, 3 weeks time. my lordship.
Finance Department.
Yes.
Finance Department, we would also like to advise you to file a proper affidavit on this letter. This is not proper. Directly addressing the registry.
But here they have taken a contrasting in their
It's all right, let them file affidavit, we will know what is the stand taken.
Yeah.
If there is contrasting or if there is an agreement.
My lordship, 3 weeks time will be given, my lordship.
You are for respondent number 3.
3, my lordship. For the first time I'm appearing.
What about 1, 2?
They've already filed.
Okay, 3.
Yes.
On the basis of their affidavit, only the respondent number 3 was added as respondent number 3.
You are appearing on it today.
Yes, my lordship. Today morning I have filed my wakalat number.
Okay. MS Renzo. Leonard Council submits that. She has been authorized to appear on behalf of respondent number 3. And she has filed the power on it today. So, the Leonard Council therefore 6 for 3 weeks time. To file,
3 weeks more.
3 weeks time to file,
Affidavit.
affidavit on behalf of the respondent number 3. MS so Leonard Council for the respondent number 3 shall also take note of the letter dated 26/7/2024. Which has been addressed to the Register Guwahati High Court, Itanagar Permanent Bench, Itanagar, by the Commissioner, Finance, Government of Arunachal Pradesh, Itanagar. Kindly take note of this. Okay.
But a fixed date.
After 3
First time, let the rest take some time.
Apply.
May I please, Lordship?
Yes.
Lordship, in this matter, all the respondent has filed their affidavit in opposition, except for respondent number 6.
Respondent number 6. Who is the respondent number 6?
Messrs. Durga Motors. It's a private respondent, Lordship.
Oh,
So despite service of notice through Dusty, in compliance of the order dated 26/3/2024 of this honorable court,
26.
26/3/2024. This honorable court was pleased to
26. 26/3.
2024.
Oh,
So this honorable court was pleased to allow the petitioner to take.
have you filed affidavit?
Yes, Lordship. I have filed it on,
Stating service of Dusty.
yes, I have filed it on 8 April 2024.
8
April.
April.
So Dusty has been completed with regards to respondent number 5 as well as respondent number 6.
So notice is deemed completed as per the order dated 9/4/2024.
Yes, Lordship. So now, Lordship, after this, respondent number 5 has already filed their affidavit in opposition. But with regards to respondent number 6, despite service of notice, none has appeared. So may I pray that I may be allowed some time to file affidavit in reply with regards to affidavit in opposition filed by the state respondent as well as respondent number 5.
State is also filed.
Yes, ma'am. That's fine.
You're for respondent 5. Mr. So the Leonard Council for the petitioner is allowed 2 weeks' time
Lordship.
to file affidavit in reply to the affidavit in opposition filed by the state as well as by the respondent number 5, listed accordingly. Okay.
Deeply obliged.
Yes. Respondent number two still awaited.
Yes,
Who is
Lordship.
respondent number two? The others are appearing.
No, Lordship.
Madam, you're for
One, my lordship.
only one.
Yes, my lordship. 1, 2, 3, 4, and 5, my lordship.
2, 3, 4, 5, correct.
Yes, my lordship.
Respondent number two. What about respondent number 6? 7?
They are private respondents.
5, 6, and 7.
6 and 7?
Private respondents.
Lordship, we may be allowed to take steps toward justice service to respondent number 2, 5, 2, 5, and 7.
Two ma'am as
2, 6,
represented.
2, I'll be.
5, 6, and 7, Lordship.
6 and 7. my lordship.
5 also ma'am you are representing?
Yes, my lordship. Common opinion.
Lordship, we may be.
6 and 7.
Yes, Lordship. We may be allowed to take through justice service.
The Mr. Sensor, the learned counsel for the petitioner is allowed to take service of notice by dusty process upon respondent number 6 and 7 within a period of 7 days from today.
Yeah.
And file affidavit to that effect, listed after 3 weeks.
And my lordship, extra copies will be served.
Yes, the requisite copies of the writ petition shall be furnished to the learned government advocate. Correct?
My lord, item number 26 is IA file for. My lord, yes. 26 is 226 tree application, my lord. Against the interim order passed in item number 28.
My please, your lordship. I'm for the opposite parties in the item 26, the IA file for vacation of interim order. Since it's coming up for the first time today, I may be given some time to file a reply to this.
Where is your application for vacation? In which IA? Is it in this IA 137?
Yes, 26, item number 26 is there.
You had filed for vacation of the interim.
Yes, yes.
Where is that application? How can you directly file an application under 226(3)?
My lord, I am respondent in writ petition number 295.
Okay.
And this interim was passed without hearing us.
Okay.
So
you are filing for modification?
Yes.
Why invoke 226(3)? Why invoke 226(3)? At this very first instance. 226(3) will come into operation only after 14 days of your service of the application to
yes,
the
my
other
lord,
side.
that's why, my lord, let them take.
That's
some
why I'm
time,
asking
yes.
you. When did you receive this application?
Yesterday.
Yesterday. Okay. Okay. You file your, are you filing any objection?
Yes.
Okay. Ma'am, you're the counsel for the
Petitioner in items 27 and 28.
petitioner in item 27 and 28.
Yes, this IA has been filed in item 28.
So you're for the petitioner opposite party,
Yes,
MS so. Learned.
notice may be issued in the IA.
Pardon?
Notice may be issued in the IA. Item 26.
Oh. This is coming up for the first time?
Yes.
Okay. Mr. So and so. Learned counsel for the applicant. The present application has been filed under Article 226(3) of the Constitution of India, praying for alteration, modification / vacation of the interim order dated, of the ex parte interim order dated 31/7/2024, passed by this court in WPC number 295 within bracket AP/2024. Issue notice to the respondents, returnable in 2 weeks' time. MS
Ed
so-and-so
Duncan.
appears for the petitioner respondent.
Opposite parties in the IA.
Appears for the opposite parties / petitioners. All.
Yes, 1 to 3, sorry.
Yes,
1 to 3.
Therefore, no formal notice need be issued to the said opposite parties. The learned counsel for the applicant shall however serve the requisite copies of the application to the learned counsel for the opposite parties / read petitioners when?
In 2 days.
Within a period of
2 days.
2 days from today. Since you have filed this application under 226(3), you have to hurry up
Yes.
within a period of 2 days from today. Okay.
My lord, in item 28, interim order may be continued.
Item 28.
Yes.
Item 28 is WPC.
The WPC 295.
Okay. Item 28, correct?
Yes. 295.
The interim order passed. Ma'am, earlier shall continue till the next returnable date.
Obliged.
Okay, obliged. Yes, Mr. Chaudhary, what is the matter about?
This is selection of the member of Electricity Regulatory Commission.
Why
Yes,
all,
the petitioner has challenged the selection.
why all this papers of holy no?
This
Sorry.
pleadings are otherwise complete.
Ah,
So this has come up for hearing. Finally.
step a little, let's see.
May,
Yes.
may I please, Your Lordship? My lord,
Yes, give me the G's first without going into the application.
yes, my lord. My lord, what happened was that there was an advertisement. There was an advertisement for the selection of chairman, chairperson and member law in the Arunachal Pradesh Electricity Regulatory Commission. So what happened was that after that, the total 14 applicants, especially the petitioner is one of the member, and 2 candidates was shortlisted.
Two candidate was for the
Shortlisted.
out of the 14.
14, yes, my lord. There was a committee is headed by the retired judge, and then chairperson of Central Electricity Commission and one more member. So this committee was there. They constituted and they scrutinized, and they shortlisted 2 candidates. One of the petitioner is a number 1, and then respondent number 4 is a number 2. And then
Petitioner is one of the selected candidates.
one of the shortlisted candidate, my lord.
Shortlisted.
Yes, my lord. But as per the act, it says that final list. But then it has to be read with another clause, which is says that recommendation has to go to the state government. The act says that finalize the list and then recommend to the state government. Now in the list, the petitioner is a number 1 and the respondent number is respondent number 4 and serial number 2. Now, if you see the comparative of their experience, and there is also a Supreme Court judgment also says that the person should have a substantial practice in law. That's very clear as per the judgment. So I will be placing that one. Now the petitioner has 14 years of experience. He has submitted all the experiences of
14 years of what experience?
14 years of legal experience, my lord.
Okay.
And then petitioner is only, it shows that's only 7 years. But then as per, if you see the biodata, he has never mentioned that he was a practicing lawyer.
Who has
the
that
respondent number 4.
Respondent 4. Okay.
He just only mentioned that I am enrolled in such and such date, and as per that, he has only 7 years of experience.
Is it an essential requirement?
As per the act, it says that
State or central?
Yes, a state. He should be eligible for the High Court judge and session judge.
He should be eligible.
For the High Court judge and session judge.
High Court and session.
Session judge. Now, question here is that as per the judgment, also it says that there should not be a pick and choose. If somebody has to be selected, then he or she has to have a substantial practice of the law now. Now, what happened was that they have picked only respondent number 2 or respondent number 4, and then not respondent number 1. So now that is 1. And there is no any ground that on what ground the respondent number 2 has been selected. What we are saying that there is no reason. Otherwise, even for the vigilance clearance also, the respondent number 1, the petitioner has submitted. They have short.
You are also one of the shortlisted.
I am in number 1.
Your petitioner is number 1.
Number 1, my lord. The same thing, even in the chairperson, there was a 3 person was there was three person was shortlisted, but they have selected only 1 person. But then who were not shortlisted, they have made a ground. Why the 2 persons are not selected? There is a ground. But in my case, they have picked up serial number 2, but there is no any ground. Now, when we short through the RTI, then why number 1 is not selected? Why number 2 is picked up? Whereas number 2 has no any substantial practice of law. And as for the experience, if you see the biodata also, he has not submitted any say that I practice some in this court. I have been standing counsel. Nothing is in there. Only say that I was a student leader. I was the agent of the political party. This is all in the biodata. Now, as for their reply, RTI, even in the affidavit, that they says that the government has got a discretion.
Government has
that discretion. That is one. Another reply, they said that government has got the prerogative. Now, question here is that whether the government when the candidate has to be selected as per the statutory provision, that is called the Electricity Act 2003. It has clear about that. Now, question is that whether the government can have a prerogative or whether government can have a discretion. That is the only your lordship has to see, my lord. Only that has to be seen. Now, if you see the file notings, what happened was that in the file noting, there was some government's politicians' intervention was there. They said that number 2 has to be picked up. That is a file noting, so that number 2 has to pick up. That's how the number 2 has been selected instead of number 1. And there is no any reason why number 1 has not been selected. Whereas as per the vigilance clearance, they have asked from the petitioner also that you should submit that. Vigilance clearance was short from the two person. One was for the chairperson, one was from the petitioner. But that is a different issue. But then even the vigilance clearance was short. But then in the case of a lawyer, let us say they said that we don't need vigilance clearance for the lawyer because they are not government servants. So we don't need any government vigilance clearance. Now, the other side's dispute is that the petitioner was holding the office of the profit. He was a standing counsel of some cooperative. We have contradicted that he was a standing counsel of a cooperative which is not governed by the state. And as per their advertisement of the chairperson, it clearly says that even if they were holding a government job, once you are appointed, they can resign and get it. If they're selected, they can hold the post. That's the situation now. Now, my submission will be that your lordship has to see is that whether the government has a discretion or government has a prerogative. If the government doesn't have a prerogative and discretion, then the matters goes in favor of the petition. So that is the case, my lord.
Okay, we resume at 2.
Right.
Resume at 2. Okay. Yes.
Yes, may I plead, your lordship. May I just take to the advertisement minute? Advertisement is in page 20 and 22. Minutes. Page start from 20. And I will just take to the type copy page 20A.
Take all this. This should come with you. Oh. Maybe the big stapler, you take it. That is.
Page 20A. Merits advertisement for a post of member law.
Page 28 is an order dated 2/2/2007.
Page 20A, my lord.
28.
20A.
Oh, 208.
Yes.
208.
Yes, my lord. 20A. Page 20A. It's start from 20, page 20. Type copy is in page 20A. So may I read that type copy?
Page 20.
Yes. 20A is a type copy. My lord, got it, my lord. 20A, may I read? dated 21st June 2022. Merit, Government of Arunachal Pradesh invites application for the post member law bracket law of the Arunachal Pradesh State Electricity Regulatory Commission to be submitted in prescribed format latest by 4 p.m. on 29 July 2022 to the Under Secretary Power, Civil Secretary Itanagar. Interested candidate may visit the following website for details, madam. And then next is my lord, application for the post. Next is the details of the name, personal details, and then my lord 9, serial number 9. 9 talks about the details of experiences. My lord, that is important, my lord. Details of experiences, and 10, any other relevant facts the applicant may like to share. So this is the advertisement, my lord. Now, after this advertisement, my lord, page 22 is the page, may I take to the page 23, annexure B. Annexure B is the application submitted in the format.
No, but the details of experience, what is there in the advertisement?
Advertisement, they have not specified, my lord. Only the detailed experience, my lord.
Then how can we import the experience? How can we import?
My lord, the committee has decided on the basis of judgment, my lord.
On the basis of?
Judgment, my lord. As per the Supreme Court judgment, there is one judgment. It's talk about the person should have a substantial experience of law, my lord. As per the advertisement, there is no any specific, but then as per the egg, my lord. As per the egg,
Mr. Chaudhary, what is this vague details of experience?
Actually, that is not required. What it is, they have determined it, there is a Supreme Court judgment. As per that, what they have provided is, if a person is eligible to become a district judge, which requires 7 years of experience for being appointed as a district judge. So they have set that as a benchmark, that if you have 7 years, you will be eligible. And what my learned friend is, perhaps the petitioner is confusing. He is treating this as if it is a select list prepared pursuant to assessment on merit, like serial number 1, serial number 2. The act itself says that the selection committee will prepare a panel, not a select list. So they will, out of the number of applications that will be received, so they will prepare a panel, like in the case of DGPs. The state act say, at least the Assam Act says, that a selection will be conducted and a panel of 5 senior police officers will be prepared. Out of the panel, the government will be at liberty to select any one of the 5. So what the petitioner is contending is as if it is a select list, serial number 1, 2. And therefore, since his name is the serial number 1, he is a better candidate.
No,
he should have been appointed.
No, not only that, my lord.
That is not the case. The act.
I will just, the advertisement has to be, my lord, has to be read with the act. There is a qualification, my lord.
Now let us come chronologically. Details of experience, nothing is there.
Yes,
So how do we import?
No, but my lord, I just before that, for my lord, for understanding, my lord, may I just take to the act, Arunachal Pradesh, sorry, the Electricity Act 2003. I'll just
You are reading page 22.
No, my
Let
lord.
us finish this.
My lord?
You were on page 23.
Page 23 is my application, my lord. I have submitted my application, my lord. And also I will take to the comparative statement of the qualifications of the candidates, my lord. So 23 is the application in a format, my lord. Your lordship may see serial number 9, and it's a detail of experiences, my lord. He has mentioned it's practicing for law for 20 years.
Okay.
This is the experience, my lord.
Let us go to the act.
Okay, my lord. Act, my lord, yes. Now I will just take to the act 84, my lord. 84 talks about the qualification.
Page
49. May I read that one, my lord?
Yes, wait, 49.
49, my lord. No, qualification is in the act, my lord.
That's why I want to, page 49.
No, my lord, act, Electricity Act. Just, that, bare act.
But I think I must, before my learned friend proceeds, if he is arguing for a final disposal, this case is likely to take 4 or 5 hours. I am sure he will take about 2 hours. And naturally, I'll have to give a reply. So.
If we can't finish, we keep it parted next week.
Yes, that can be done, my lord.
Next week again, I have quite.
One day we can give next week.
Yeah.
Next week, my lord, I am totally, Monday is a holiday. 27th, 28th and 29th, my lord, there are quite a few parted matters in Guwahati. But 30th I can spare.
After that, I can't.
After that, your lottery. Oh, instead of, I thought I must clarify.
No, I will not take, I will not take much.
Well,
I will not take much, my lord. I'll just brief and little bit on the law and then some citation, but that's all.
I will leave it to your lordship, but I thought
Page,
I must
page
make my
49.
position clear.
Let's hope that the hearing is not futile, okay?
Yes, yes, my lord.
If we can't hear it, then we release it again, even after.
I think after my submission, your lordship.
How long you'll take, say, Chaudhary?
It depends how much.
And what about the others? There are others also?
Other respondents are there, my lord.
You will also argue?
But not much to say, my lord, not much to say, my lord. His argument is only on the office or profit, that's all.
So how can he say and debar me from saying? How can he say that what I?
Of course.
No, what I'm saying is that it will not take much.
On merit, other than office of profit, I have also the right to make my submission.
Obviously.
Oh.
I'll just.
You will be arguing this much only.
Yeah. Okay.
But
I'll just take to the
take at least.
page 49, my lord. Page for the Electricity Act. My lord, may I take, let's see the page 49.
Qualification for appointment of chairperson.
Yes, my lord. May I read that one?
This is section 84.
84. Qualification for appointment of chairperson and member of the state commission. 1, clause 1. Chairperson and the member of the state commission shall be a person of ability, integrity, standing, who have adequate knowledge of and have shown capacity in dealing with problems relating to engineering. My case will be not engineering. My case will be finance, commerce, and law, my lord. Law is there, my lord. So this talks about he or she should have adequate knowledge of a law, my lord. That is a minimum qualification. And advertisement has to be read. The detailed experience in the advertisement has to be read with this section, 84, the qualification, my lord. And then yes. And then this is 84 is talking about the qualification.
It only speaks about adequate knowledge.
Yes, my lord.
You are emphasizing on law.
Yes.
So it must have adequate knowledge on law.
Well, adequate knowledge law in the sense he should have a substantial practice in law. I have a judgment which is of 2018. It talks about it's a mandatory. He should have a substantial experience in law. It talks about that. He should be appointed.
How do we judge that parameter?
Parameter, yes, my lord. Parameter, I want to take that one. Your lordship has seen my application, page 23. Now, I will just take to the comparative statement of the candidate's experience, my lord. Now, your lordship may just take to the page 65, my lord, in my petition, page 65.
No, you're emphasizing on qualification, so let us be very clear with that.
Yes.
Because ultimately, your case has to be judged. One of the factors to judge your case is this.
Because my case is also experience. My support will be as per the section 84 and the one of the judgments, I will refund that one. As per that, it says that the candidate should have a substantial experience of law, my lord.
Okay, you may have more experience than the other,
Yes, my lord.
but just by having more experience, that does not give you any right to be appointed.
Yeah, well, yes, my lord.
The right to be appointed lies with the government.
But then by the, my
They
lord,
may have some parameters to judge who is the right person to occupy.
yes, my lord.
Yes.
But there has to be a reason, my lord. While appointing a respondent number 4, there is no any reason. They are not able to give the reason why he has been picked and appointed. When they have recommended 1 and 2, petitioner number is the 1 and then respondent number 4 is 2. When they are considering number 2 as a member law, then they should have a reason that why the number 2 has been picked up, number 2 has been
What Learned AG is saying is that number 1, 2 does not actually decide that that should be the merit.
No, my lord,
My lord will, that is why, your lord, most important provision my letter friend is yet to place. Your lord will kindly take the act one. Section 85.
Selection of Constitution Committee.
Two things, sir. Your lordship will kindly come to subsection 4 of section 85.
Subsection 4.
Yes. The selection committee shall recommend a panel of 2 names for every vacancy referred to. So the selection committee conducts the selection and recommends a panel of 2 names. It is not in order of merit that someone's name is that serial number 1 means that he is more meritorious.
And the state will make the appointment from the panel.
So therefore, no right has accrued to him.
My lord has to read.
His name is there in the panel.
My
He
lord,
has not challenged this election.
my lord has to
He
read.
is simply saying the appointment made, which is in terms of section 82(5), subsection 5 of section 82. The government is supposed to make an appointment from this panel so prepared by the state.
Whether appointment has been made.
Yes, yes, long
The
back.
government has made
Yes,
appointment.
And he has not challenged the selection of the selection committee of recommending a panel.
No, we are not challenging the selection committee, my lord.
So therefore, what
That
right,
is the-
firstly, to issue a mandamus, your lordship is aware, he has to have some right. Where is the right?
I think he has not read the section 3 of the only section 4. Section 3, my lord, may read that
Yeah.
one. Selection committee shall finalize the selection of the chairperson and member within 3 months from the date on which a reference is made.
Finalize the panel.
Yes.
Finalize the panel.
Yes.
Not finalize the appointment.
But-
Finalize the panel and the panel will be submitted to the state government. State government will make appointment.
But then, my lord,
That is-
my submission here is whether
And Mr. AG is right, when you have not challenged the selection, the panel.
But then what we are saying is that if they're considering number 2, there has to be a reason, my lord. It's a principle of a natural justice. When they consider someone, because it is under the appointment is under the statutory provision, my lord.
That let the government justify as to why respondent number 2 has been appointed. Now you justify as to why you have not challenged the selectmen.
No, my lord. As for them, my lord, in their counter affidavit, they are saying that it's a discretion and prerogative. But then I have some judgment which talks about in this appointment, there can be a discretion, there cannot be a
You are
prerogative.
jumping to a height without actually looking below. That is what I find.
My lord, yeah, you always may see the selection committee's decision, how they have decided in the minutes of meeting, my lord. I will just take to the why they have referred the judgment, my lord.
No, selection committee is only to select the panel of 2 names.
Yes, they have. But then, my lord, even in the vigilance report, they have not short from the respondent number 4, only from the chairperson and then petitioner, my lord. It also clearly indicates that they were considering number 2, the petitioner, but I don't know, a letter says how they have decided not to consider number 1. They have short on vigilance from only 2 persons, chairperson, present chairperson, and then petitioner. Even in the committee also talks about, my lord, I'll just take to my lord, page 37 and 39, there is a committee decision on the basis, they also referring to the Supreme Court judgments, my lord. Before that, my lord, I want to just to show how in the advertisement it is mentioned the detail of experience, my lord. I want to show the experience of the respondent of 4.
No, the details of experience were in the advertisement. Nothing is mentioned.
But detail of experience is there, my lord. It means
you can't import. You can't impose something which is not there.
But then, my lord, in the minutes of meeting, my lord, they have mentioned the judgment. Well, I will refer the judgment, and then the committee has referred the judgment, my lord.
Forget about judgment now. You satisfy me on facts first. Judgment I'll come later. But without knowing the facts, I will not go into judgment.
My lord, that's what I want to take to that minutes of meeting, my
That
lord.
is why I'm raising all this question on facts.
My lord, you also may see the page 65, my lord. I'll just take to the experience, my lord. Page 65, my lord. In the advertisement, there is no details talk about that.
That is why I want you to satisfy me on that point. On that point, on the advertisement where no qualification is prescribed. Particular qualification is prescribed.
But only he should be eligible for the High Court judge and then session judge, my lord. The High Court judge and district judge.
That is as per the act.
This is as per the act, as per the judgment also, my lord. High Court judge is for chairman.
Chairman.
Yes.
And
then district judge.
So this is for member.
Member, my lord. So, my lord, I'll just take to the experience of respondent number 4, whether, no doubt, it is not mentioned in the advertisement, but then it is mentioned that detail of experience that is there, my lord. So
Where?
I know.
Detail of experience where?
Detail of experience, my lord. It is my understanding is that, my lord, it should be a legal practice, my lord.
It is not your understanding. It is what actually the advertisement and the intent of the government is.
Because the post is the member law, so at least it is presumed that he or she should have a substantial experience in the law.
That is why I'm asking you, where is that which has been laid down, that the criteria which has been laid down by the government? Because in the advertisement, something is very vague. So I want to know from you if there are any other notifications or circulars which lays down
that specific, my lord, detail.
You are actually saying that you are more qualified. The private respondent number 4 or 5 does not have that qualification. So you satisfy the scope.
Yes, my lord. That's what, my lord. I want to show that the experience of the respondent number 4, whether he's really eligible for a district judge, my lord. Have to see, my lord. Only mentioning 7 years experience doesn't matter that he can become a district judge, my lord. That also has to be seen, my lord. Because unless if he's enrolled in as a law, he should have some experience to become a district judge. Suppose if he apply, but if he has not practiced, then he cannot become a district judge. That's also, my lord, it has to be seen, my lord. As per his biodata, when it is mentioned that it should be in a format and detailed experience has to be in has to be submitted. As per his experience, my lord, there's nowhere he's a legal experience. He only mentioned that I am enrolled in 2012, only 7 years. That is that much. So now enrollment in 2012, only 7 years, maybe 7 years, but he may not be practicing, my lord. Can he be eligible for a district judge? That is the issue, my lord. Because as for the act, it says that he should be eligible for a district judge. $64, my lord.
So you are saying that the private respondent is not eligible?
My lord,
He has to first challenge the selection, but he has not challenged the selection itself.
That's the move, I think. You cannot just presume or assume that the respondent is not eligible for the post. You cannot just presume like that.
My lord, I will just my lord, I will just my lord, in fact, my understanding is that advertisement should has to be read with the act and as per the committee's decision, also they have briefed for the judgment. That is, the
No,
state of,
whether the state of Arunachal Pradesh has any rules on this.
yes, my lord.
Arunachal Pradesh.
Doesn't have a rule, separate rule, my lord. Only the state electricity act has been applied.
State Electricity Act.
No, the central act has been applied, my lord. The electricity act 2003, my lord.
Yeah. And whether this act is applicable in the state of Arunachal Pradesh? Yes.
It's a central act.
Okay.
So I will just only, my lord, before, my lord, that this one of, I want to refer the judgment. Judgment has been.
Let's come to the facts. Let us, judgment afterwards. Let us see whether time permits.
No, my submission will be that, my lord, their submission is the prerogative and then discretion, my lord.
Your submission. You are the petitioner, you prove
No,
your
my lord,
case.
their submission is that they
Mr.
can.
Mr. Mo, you know that if you have filed a writ petition, then you have to prove your case. You cannot actually stand on the weakness of the other side.
No, my
You
lord.
prove your case.
My lord, my case is that, my lord, if the appointment has to be done under the statutory provision, then they cannot be a discretion, my lord. They cannot be a prerogative, my lord. I can, my lord, place some judgment.
Before going to that issue, you have to satisfy this code that the respondent number 5 is not eligible for the. You have to first satisfy that.
No, that's okay, my lord.
No, it's not okay. I'm on that.
Okay, my lord, my submission here is that no doubt they have recommended panel number 1 and 2. Now, if the panel number 2 is considered, then is it, my lord?
Number 2 has been considered.
Yes, my lord. But
and you are challenging, the.
But there has to be a reason, my lord. They have not. They have any reason, my lord. Only their submission is that a discretion and prerogative, my lord.
But you have to, at the same time, you also have to substantiate that the respondent number, private respondent is not eligible, does not have the requisite qualification or the criteria. That is up to you. That is for you to actually satisfy this court. It is not for the court to ask them. It is for you to satisfy this court.
Yeah.
Since it is a petition under 226, you have to satisfy this court. You have to make your case. That is why this court time and again has been emphasizing on the advertisement, the requisite qualification, and if the respondent, private respondent is not qualified for the post, how? That is what I am asking you, and I want to extract that from you.
Yes, my lord. My lord, in fact, yes, we have no challenge that the proceedings, the minors of meetings, but then our case is that if panel 1 and 2 is considered, then also there has to be a reason, my lord.
The AG is actually assisting you, when you have to challenge this. He has actually brought this to your knowledge. In fact, actually, I am also many on that, because that is actually the basic decision.
But in our
the basic decision.
But in our petition, is our challenge was that it is a merit. Decision was on the merit, my lord. That is our submission on that, my lord.
Mr. Mo, I think you will have to be a little bit more detailed.
I'll just take the judgment, your lordship.
No, I'm not on the judgment. I will afterwards, only after satisfying on the facts. You still have not satisfied me. And you have also not challenged this panel.
That is there, my lord.
Why don't you come with all this prepared?
Then, my lord,
See, when you are going to argue a case, more particularly when the learned AG is there, I think you should not leave any stone unturned.
my lord, it is at this hearing stage, but by then now I'll pray that we want to include that minor submitting. In fact, we should have challenged that one. If you are challenging the qualification of the petitioner, the respondent, but we have not challenged the minor submitting, my lord.
If that is the case, then you have to file for amendment of your
Yes,
petition.
that's what I will
And
pray.
that will be subject to the objection raised by the other side. That is.
You will have to file a IA to praying for an amendment of the.
Correct, exactly, that's correct.
In that case, let him file an IA.
Because I think everything has to be decided. We cannot decide in piecemeal.
Yes, my lord.
We cannot decide the case in piecemeal.
Then, yes, maybe given some time to.
No, you are a very seasoned lawyer. You know the law very well. That if basic
But
orders are not
basically-
challenged, you cannot challenge
basically-
only the constitutional orders.
My lord, my understanding was that the law, the section 8, section 85 of 3, it talks about the final selection, my lord. That's
No,
we are
no,
based
no,
on
no.
that.
The learned AG has said it's only a panel which is subject to the approval of the state government. Without challenging the panel, you are straight challenging the appointment.
But my other argument is also that
I must, since he is thinking of filing an IA for amendment, I must point out. His writ petition is self-contradictory. On the one hand, he is saying that I am at serial number 1. So
Correct.
therefore, he wants to take the benefit of that position in the panel. But at the same time, he is questioning the eligibility of the respondent number 4 without challenging the selection.
Without challenging the panel.
That
is the issue.
That's what we are praying that we will also challenge that minor
issue.
submission. Yes,
That is the issue. So we give you that opportunity to file an
Yes, madam.
application.
Yes, madam. That's
But
true.
that will be subject to the.
Let him
objection.
file an IA. Your lordship will simply mention that he wants to file an IA for amendment. And we will file our objections that can be taken up independently.
Incorporating which? Incorporating which? IA incorporating.
No, we
Your
want.
lordship will not
No,
say, because that will make him wiser.
no.
Your lordship will simply say.
No, my lord. No, we want to impugn the minors of meetings, my lord. That anyway, we will annex in the IA, my lord.
Okay, we just.
My lord, we want to impugn that.
We just give you that liberty to amend.
Yes, my lord.
Okay. In the course of a hearing, Mr. S. Mo, am I right?
Yes, my lord.
The learned counsel for the petitioner submits that he may be granted the opportunity to file an application for amendment of the writ petition, bringing certain vital facts. Stop. Prayer is allowed. Petitioner is allowed to file application for amendment of the writ petition listed.
Maybe after 1 week, my lord.
Mr. I. Chaudhary.
We will file.
I have to come for the other
Yes.
matters. Let it be on 23rd September.
20 listed on, okay, 23, 9, 20, 24. Yes, next, Mr. So-and-so. Okay, let us come serially, Mr. I. Chaudhary, learned advocate general, assisted by Mr.
L. Park.
So-and-so, appears for the state respondent, and Mr.
Yes, Chakravarti.
So-and-so, learned counsel, appears for the respondent number 4. So we are not we have not particularized anything about your amendment.
Right.
Because the learned advocate general has said that you will become a more voice.
It's okay, my lord.
So explore everything. And
Yes, my lord.
Okay.
Yes, my lord.
Okay. Next.
Obliged.
Okay.